Well, you took up half my presentation time, so if I can figure out how this, okay, I think I got it. And it works. I'm assuming that those of you in the back can't see what I have up here on the screen, so basically, I'm not going to talk about what you typically think of with a hunting lease. So I was going to try to get on the internet, but they said the connection's really slow. If you are interested in seeing an actual hunting lease and looking at some of the things that should be in it, go to the AFOA webpage. There's on the home page, there's a link that says hunting land for lease. If you click on that page and go to the bottom, there's a section on hunting leases. And the first thing I want to tell you is it's not a lease. Okay? And so what I'm going to tell you real quick, what I'm going to talk about. It is not a lease. I'm going to explain what a lease is and why this agreement you signed is not a lease. I'm going to talk about what it is, which is probably a license. And I'm going to explain that contract law applies if we're talking about a hunting agreement. And I'll talk about some of the problems. And if I have time, I'll talk about landowner liability, but I'll probably run out. If you have well, I guess I probably shouldn't open it up for questions. I'll probably never get anywhere. So I'll try to quit when he says 1 minute and see if there's anything burning question. So the first point is we called them a lease. And I was going to wax eloquent, you know, that Shakespeare line, a rose by any other name, etc., etc. I can't remember it. So anyway, so it doesn't matter that it says hunting lease on the title to your agreement. We look at what the agreement says and we determine what interest you actually transferred. If we are talking about a real lease, you have given exclusive possession to that person. So it's like the typical lease is landlord-tenant. You know, if you rent an apartment from somebody, the landlord, the owner, can't just keep a key and come into your apartment anytime he wants to. He has given you exclusive possession. The only time he can show up is if you invite him. So we are not, in our agreements, giving the hunting club exclusive right to that land. That would mean you couldn't go on the land unless you actually got permission from the hunting club. So obviously that's not what you meant. By the way, if you are interested in these slides, I'll make a copy available and I'll talk to Lee about it. We may actually put it in the next newsletter. I've got all this stuff in writing also if you happen to be interested. So I said it's not a lease. It could be something called, and I may butcher this, anybody speak French? Okay, good. A profit à prendre, which is a French word meaning profits to take from the land being implied. So your agreement could be a profit à prendre. Probably not. But for it to qualify as such, it has to be written out in the form of a deed and it has to be recorded in the probate judge's office. If you get to that point and it is a profit à prendre, then it is considered an easement. An easement law would apply to that particular situation. Okay? So more than likely you are not putting your hunting agreement in the form of a deed and recording it. Obviously it has to be a multi-year for it to be a profit à prendre. Okay, so, and there's just some language. By the way, I did a search on the internet, or not on the internet, on a legal web page on something called Lexis, and found all the cases involving hunting leases or hunting agreements in the state of Alabama, and there are only a couple. The problem is, you'll see in these slides I've got case names listed. They only publish appellate level cases. So I'm talking about Supreme Court and Court of Civil Appeals cases. There are probably plenty of cases in circuit court, but they do not get published, and they do not create law for the state of Alabama. So it's only the civil appeals and Supreme Court cases that are the law for us in Alabama. In case you happen to notice, the David Lee Boykin Family Trust versus Boykin is the kind of seminal case on this particular issue. You'll see that name quoted several times in this material. Okay, and this is just some more on a profit apprende and the fact that it has to be written, it has to be in form of a deed, it has to be multi-year. So I'll just skip through that. And this is the slide that actually explains that if it is a profit apprende, then easement law applies. Okay, so what do you really have? It is more than likely a license with an interest. Okay, so when we think of a license, and if I get to landowner liability in a minute, we'll talk about the three kinds of people on your property. You know, there's the licensee, the trespasser, the licensee, and the invitee. So the licensee is somebody that is on your property for their benefit. The typical licensee is the person you invite over for dinner tonight. They would be a licensee. You can withdraw or revoke that license at any time. So that's why we say the agreement is a license with an interest. So once you have paid money, you know what? I'm sorry. I'm looking at my notes. You're not looking at my notes, are you? Y'all are really having trouble reading this stuff, aren't you? Somebody say something. Anyway, I forgot. I usually have my computer hooked up and it's just moving right along. I'm sorry. I'm a little slow this morning. I was in Tell City all day yesterday doing estate planning. So anyway, I didn't finish this till 10 o'clock last night. So excuse me. So anyway, so you have a license with an interest, which basically means it is not revocable at will. Okay? But the point that's important on this is that if it is a license, then contract law applies. Oh, yeah. Even though I'm holding it in my hand, anyway, I'll hold it in front of my... Okay, so if it is a license with an interest, that means contract law applies. And when we are talking about this contract situation, I've got a couple of points, but the one primary point I'm about to make is you can make or you can write anything you want in your contract. And once it is written in there and it is not ambiguous, the courts will enforce that writing. And I'm going to use this Boykin case as kind of an example just to explain what I mean by that. Okay, in the Boykin case, there was a sale of a tract of timber, and the seller reserved the right to hunt on that particular land. And I'm only putting a couple of the pertinent points in here. So one of the things, it said they could not do anything that would impede the growing of trees. The land got sold to Tensall. It also said they could not put in a food plot or a planting without written permission from the owner. And it also said if the owner asked them to post the land, that they would do that with what it says there, black and yellow signs with the name of the owner and the hunting club. And the importance of that is one thing I'm going to talk about here in just a minute. Okay, so when we have a contract, what's going to happen in this case, of course, is The hunter, in this case, by the way, because this is a contract, you can assign your rights in a contract, and that was not written into this particular agreement. And so Boykin has assigned his hunting rights to somebody else. And now this somebody else is actually exercising the right to hunt on the land. They decide to plant food plots in the power line. And they're like, hey, no big deal, right? It didn't hurt the trees at all. But they didn't get permission. The other thing, the company did ask them to post the land. So they put up posted signs at the 2 gates to the property. And so I'll tell you in just a minute, that does not constitute posting. Okay, so if there is an agreement and that agreement is breached, or in other words, breach is is failure without legal excuse to perform any promise forming the whole or part of the contract. Okay, the reason I'm doing that, if the terms of the contract are clear and there's no room for interpretation, the courts will enforce them as written. And so even though in this case planting food plots in the power line did not hurt the growing of timber, they did not get written permission to do that, therefore there's a breach of contract, therefore you're out of here. Okay, so when we're talking about breach, obviously a lot of these things go to a court for interpretation. So like Monty was mentioned a minute ago, you signed an agreement, that was a contract. It said the whole property, not the 60 acres that Monty was talking about. And so when that landowner stopped them from harvesting the timber, he actually breached that contract. The landowner in that case is probably going to lose. Okay, so when we talk about contract interpretation, so quote out of this particular case in the court, it's not the province of the court to make contracts for the parties, but it's the duty to confirm the interpretation of the one which they made for themselves without regard to its wisdom or folly. So you write whatever you want to in the contract, it is enforceable. The only time, so they mentioned in this was from another case, we do not understand why the parties in their right mind should enter into such contracts, but these parties did. The court has no authority to make a contract for them. The contract, lawful in its provisions, though it may be considered improvident on the part of the plaintiff, must be given effect if at all. So the other thing to remember is if you are arguing over the contract, it will be interpreted against the person who wrote the contract. So if there is a question, it will be the person who did not write the contract, or it will be interpreted in the light most favorable to the person who did not write the contract. Because if you are the author of the contract, you had the opportunity to say what you wanted. And if you didn't do that, then it will probably go against you, which is this next issue. Well, excuse me, one more on that. So if it's unambiguous, the court has to follow it. However, in a lot of cases, we have an issue where the contracts are not clear as written. And so the only time a court will actually change anything is if the language in the hunting agreement is not clear enough that the court can understand what the author of the contract meant by those particular terms. So it says contracts that are ambiguous call for interpretation by the courts. It is well recognized if a contract is susceptible to two constructions, unconscionable results are to be avoided, and that the irrational and unreasonable was not the contractual intent. Okay. So if you write it clearly, the court will enforce it as written. If it is not written clearly, it will probably be interpreted against you if you wrote it. So just as kind of a side issue, so to me that's the legal part of the contract. So it's not a lease, it's either a profit apprende, but probably not because you probably didn't write it and record it. So it's probably an interest or a license with an interest. Therefore, contract law applies. So if it's clear, the court will enforce it. If it's ambiguous, the court won't. It's interpreted against the author. But you can put anything in there you want to. So that's why I was thinking, go back and look at that AFOA contract. And there are some other things that you may want to put in there in your specific one. So in the couple of minutes I have left, I was going to mention the importance of posting and a little bit about landowner liability. Or should we ask questions about what I've talked about before we go on to that?
I have one question, please.
Yes.
I was told at some point in time that even if you had in your contract, your agreement, that the leasing party could not sublet, that didn't make any difference.
That is not correct, okay? So a contract, if you don't say otherwise, can be assigned or subleased to somebody else. But if you have a provision in there that says this contract cannot be assigned without written permission, so that you actually have a chance to say, okay, no, I can't. So you do have to have something in there that actually says that. Okay, why is posting important? Some of you may not realize this, and to me it was kind of counterintuitive. You would think that anybody who was on your property would know it was not their property, and so they must be trespassing. That is actually not the case in Alabama. So this is right out of the Code of Alabama. A person who enters or remains upon unimproved and apparently unused land, which is neither fenced nor otherwise enclosed in a manner designed to exclude intruders, does so with license and privilege unless notice against trespass is personally communicated, or unless such notice is given by posting in a conspicuous manner. So so most people do not fence their timberland. A lot of people I know don't post it. So the importance of that is that you can't call the sheriff's department up and say, hey, there are people trespassing on my land, come throw them off. Because they are not trespassing unless you have the land posted. Now, the thing you have to realize with this, there is a difference between criminal trespass and civil trespass. Okay, so what we're talking about in this case is the criminal trespass. Now, they are still trespassers on the civil side. But that means you got to take them to court to get anything from them. So no help from the sheriff's department unless you post your land in a conspicuous manner. And the court in this particular case basically said signs 100 feet apart, facing out, so that a person could see one sign from the next and could not walk onto the property without seeing a posted sign. So no posted, no criminal liability. So when we think of landowner liability, some of you were probably at the meeting in Lake Point Park last time, and Ed Wilson talked about landowner liability. I'm going to mention a couple things that he didn't. I'm probably going to skip some of this material since I'm getting down toward the end of my time. But understand that landowner liability is based in negligence. Okay, so if you are not negligent, you are not liable. So even though you have leased this land to the hunting club, you are more than likely not going to be liable. Okay, because first of all, you will probably not have been there when the accident happened, say a four-wheeler accident or hunting or something like that. Okay, so if we look at what's required in negligence, 4 elements. So the first one is a duty that you owe, and then a negligent breach of that duty which caused damage, the plaintiff is injured. So the key is, what duty did you as the landowner owe to the people that were on your land? And 2 minutes? 1 minute? 1 minute. So I'm going to zip through a couple of these slides real quick and just... So if you are a landowner and you have leased your land out to hunters, you owe a duty to keep the premises reasonably safe, and if they are not safe, to warn of hidden defects that are known by you, but you are not required to warn of any obvious dangers. So, as a general rule, the inviter, meaning you as the landowner, will not be liable for injuries to an invitee resulting from a danger which was known or should have been observed by the invitee in the exercise of reasonable care. And there are a couple more in there, but I'm like 30 seconds away, so quick question, or if yes, sir.
How do you post if you've got land with a boundary and a public road goes through it? Do you just post around the boundary, or must you post along the public road?
Right, you got to do the public road too.
Okay.
So you basically have to have it so that anybody entering your property from anywhere that's public would see the posted sign.